Hello everyone, I am Adhistaa Subramanian and I am an intern at Law Minds. Today we are diving into the fascinating realm of environmental protection as enshrined in Indian Constitution. Did you know that initially Indian Constitution did not explicitly mention environmental protection? However, hints of it could be found in the preamble and the directive principles of state policy. But as time went by, the Indian government realized its crucial role in safeguarding our environment. That's when they decided to make some significant additions to the constitution. Firstly, they introduced the concept of environmental rights and obligations. These were incorporated into fundamental rights and fundamental duties respectively. This means that every citizen not only has the right to a healthy environment but also bears a responsibility to preserve it. Fast forward to today. Now, our constitution stands firm on the principle that the environment must be both maintained and protected. It guarantees every citizen the right to live in a clean and a healthy environment. So the next time you take a deep breath of fresh air or marvel at the beauty of nature, remember it's not just a privilege, it's your constitutional right. The Indian Constitution includes specific provisions for environmental protection within its directive principles of state policy, fundamental duties, and fundamental rights sections. However, recent judicial activism has highlighted a notable gap, which is the absence of a dedicated clause recognizing the fundamental right to a healthy and clean environment. The catalyst for change came in the 1970s with events like the Stockholm Conference and an increase in global environmental conservation movement. In response to this, the Indian government enacted the 42nd Amendment to the Constitution in 1976. This amendment introduced direct environmental protection measures, notably adding Article 48A to the Directive Principles of State Policy. Now moving on to the provisions enshrined in Constitution. Directive Principles of State Policy. Article 48A. According to this Article 48A, the state shall endeavour to safeguard the country's forests and wildlife and to maintain and promote the environment. It was determined that residents of a nation had a basic right to a healthy and clean and decent environment. This was held in Sheshan versus Himachal Pradesh. Additionally, according to Article 47, one of the state's fundamental responsibilities is to raise the level of nutrition, the standard of living, and the state of the public health of its people. Public health must be improved through environmental protection and development. Now, fundamental duties. Article 51A, Clause G. This Article 51A, Clause G addresses the fundamental obligations of citizens and indicates that it is the responsibility of every Indian citizen to preserve and enhance the natural environment, including forests, lakes, rivers, and animals, as well as to have compassion for all living things. As a result, both the state, Article 48A, which was in the Directive Principles of State Policy, and every person, which is included in the Article 51A, Clause G, have a responsibility to preserve and improve the natural environment. Now, fundamental rights section. The right to a clean environment is one of the implied fundamental rights under Fundamental Rights Part 3 as established by the judiciary using Articles 14, 19, 21 and 32. According to Article 14 of the Constitution, everyone is entitled to equality before the law and equal protection under the law. Article 14 implicitly imposes an obligation on the state to exercise fairness in its environmental protection measures. Article 19.1 has also been interpreted by the Supreme Court to address the threat of noise pollution. In the case of P.A. Jacob, 1993, the court upheld the position that using loudspeakers or sound amplifiers is not protected under Article 19, Clause 1. Additionally, Article 19, Clause 1 G grants citizens the basic right to engage in any profession, trade or business. However, this basic right is subject to reasonable limitations and citizens are not allowed to engage in commercial activities that pose a risk to the environment's health. The Supreme Court has examined Article 21, which states that no person shall be deprived of his life or personal liberty except in accordance with the procedure established by law. The court has repeatedly ruled that This act inherently guarantees the right to an environment free from the threat of disease and infection. In 1988, Dehradun Quarrying case, the Supreme Court declared that the right to a healthy environment is a natural outcome of Article 21. The Environment Protection Act was invoked in this case, and the Supreme Court order quarrying to cease. Additionally, the Supreme Court ruled in Subhash Kumar versus State of Bihar that Article 21's right to clean water and air qualifies as a fundamental right. Article 32. Most environmental pollution and ecological imbalance cases were brought under Articles 32 and 226 of the Indian Constitution. A well-known fundamental right called Article 32, that is, the right to constitutional remedies, allows any party to file a writ petition for environment protection or a PIL, public interest litigation, with the Supreme Court of India, challenging any action that puts people in danger or harms the environment. The Supreme Court has the authority to issue any ruling or order giving immunity from such activities. Article 253. This article states Parliament has the power to make any law for the whole or any part of the country for executing any treaty, agreement, or convention with any other country. Simply put, this article contends that Parliament has the authority to pass laws pertaining to any issues related to the protection of the natural environment. To put into effect the Stockholm Conference, certain acts were passed under this provision, like the Air Prevention and Control of Pollution Act 1981 and the Environmental Protection Act 1986. Steps taken for environmental protection based on the constitutional provisions. Now let's move on to the different kinds of steps that has been taken in order to protect the environment in line with the provided constitutional provisions. On the basis of the constitutional provisions, the government and the judiciary have come up with many legislations, policies, rules, and international treaties. First, the Environmental Protection Act 1986, the Water Prevention Control of Pollution Act 1974, the Air Prevention Control of Pollution Act 1981, the Biological Diversity Act 2002, and other legislations were passed by the Parliament to safeguard the environment. On the basis of these provisions, India has signed many international legislations, conventions, and treatises. Wetland Convention, Ramsar Convention, Montreal Protocol, UNFCCC, Climate Conventions, Kyoto Protocol, Biological Diversity Convention, and etc. National Biodiversity Authority, National Ganga River Basin Authority, Wildlife Crime Control Bureau, National Tiger Conservation Authority, and many other regulatory bodies were formed on the basis of these constitutional provisions. Protected areas including national parks, wildlife sanctuaries, conservation reserves, and community reserves comprising significant habitats have been established based on the provided constitutional provisions. The Bombay Natural History Society, the Wildlife Institute of India, and the Salim Ali Center for Ornithology and Natural History are a few of the research institutions established for wildlife protection. Different policies and plans like National Biodiversity Action Plan, National Water Policy, National Policy, and Macro Level Action Strategy on Biodiversity, and National Forest Policy are formulated through the constitutional provisions provided under the Indian Constitution. For the recovery of endangered species like the hangul in Jammu and Kashmir, snow leopard in Jammu and Kashmir, Himachal Pradesh and Arunachal Pradesh, vultures in Punjab, Haryana and Gujarat, and Nilgiri tar in Tamil Nadu, an integrated development of wildlife habitats plan is being implemented based on the constitutional provisions. Project Tiger, Project Elephant, Crocodile Breeding Project, and Project Rhino are some of the species-oriented projects to protect biodiversity, and the environment has been launched. The Government of India has passed numerous laws and regulations to combat environmental protection, but these measures sometimes fall short of what is needed to keep pollution levels under control. Each citizen must take the initiative to reduce environmental pollution at their own level and raise awareness of environmental protection for all living beings. Concluding my speech and presentation on this. Previously, the Indian Constitution did not explicitly mention the term environment or include specific provisions for environmental protection. However, it is crucial to note that the Constitution serves as the supreme law of the land, containing sections that can effectively address environmental concerns. While the government has implemented various efforts for environmental protection, it is the judiciary that has demonstrated innovative and bold actions in interpreting constitutional provisions to safeguard the environment. Together, these constitutional provisions and judicial interventions play a pivotal role in advancing environmental protection in India. This is my presentation on the constitutional provisions provided by the Indian Constitution for protecting the environment. Thank you.